So I'm going to move along to talk a little bit about protection of Indigenous knowledge and cultural expression. All right, so as I mentioned, this often, Indigenous knowledge and cultural expression often gets classified with these terms, traditional cultural expression or TCE, and traditional knowledge or TK. These particular definitions come from the Government of Canada. There are other definitions, though, that you might choose to look at. This is relevant just because this is how the government's currently looking at trying to protect these works. So we're going to focus specifically on the first of these two, so traditional cultural expressions, because we're in the copyright context. So looking at how the copyright law currently fails to protect the Indigenous, the ways that Indigenous cultural works are expressed, including like oral stories, artwork, handicrafts, dances, fabric, songs, or ceremonies. Traditional knowledge is often more associated with either mostly patents and occasionally trademark law, but it's something that is also a big topic worldwide right now. So in what ways does Canadian copyright law deal with sort of the protection of traditional cultural expression, and in what ways does it not? There's a lot of different issues that arise here, and a lot of them come from the fact that copyright law is not really designed to protect a cultural expression, but rather an individual expression. So when it comes to styles of work, for example, or oral stories or dances, those things often have developed over long periods of time with many different authors, and have sort of an idea of collective ownership. So they don't have one single owner. That makes it very difficult under Canadian copyright law to protect those works, because Canadian copyright law is focused on the idea of there needs to be one author, absent certain limited joint authorship structures. The term of protection is based on the idea of there being only one author, so it's based on the life of the author plus 70 years, whereas in Indigenous, when it comes to Indigenous cultural works, oftentimes the expectation for protection would be indefinite, because these are, that's the whole point. These are long-lasting ancestral cultural expressions. Another issue that arises comes with the fixation of oral works, and I'll give a very specific example, although there are other ways that this can be relevant. With the Maliseet First Nation, is a First Nation that a while back hired somebody to record oral stories from their elders, important cultural stories. And under Canadian copyright law, when it comes to a sound recording, the person who actually has copyright protection over a sound recording is the person who created the recording. So the person who recorded the work, not the person who spoke in the work. Certainly, the Maliseet First Nation would still have protection over the expression that provided within those stories, but the person who actually recorded them and the person that they hired to bring in had protection over the use of those sound recordings. And that meant that after that person decided not to publish those works, the Maliseet First Nation was not able to publish those works and was not able to make these stories that they had initially intended to use to sort of preserve their cultural experiences, was not able to make those public. And it took several years before eventually the Maliseet First Nation simply overcame the fear of litigation and decided to publish these works anyway. But by that point, all of the elders who had spoken in these works had since passed. So the fixation requirement in copyright law and the ways that interacts with sort of who gets copyright over what is really concerning. And similarly, fixation of oral works, the reason that fixation is a requirement in copyright law in the first place is that fixing a work is considered to create an evidentiary record to allow us to understand whether something has been copied. When it comes to oral storytelling traditions, though, the ways in which we develop evidence for the existence of works and for whether something might have been copied over time is very different, and it relies on oral storytelling. It doesn't rely on some sort of fixation in a tangible form. So the entire purpose of there being a fixation requirement is really counter intuitive to many different types of Indigenous frameworks, and so creates, again, a significant issue. Similarly, there are issues when it comes to exceptions and limitations to copyright protection with respect to sacred works. Should sacred works continue to be protected? Even where an exception or limitation might apply, and what do we do with works that have been stolen over centuries and centuries?